Welcome to another episode. I'm your host, Ryan Richards. I'm a loan officer with North Point Mortgage, and today I have a very special guest, Josh Cali, joining me. He's the owner of Cali Law, practicing in the real estate attorney side as well as estate planning attorney. Overall, just a wealth of knowledge for all things real estate law, and I'm very excited to have him join me today. So, Josh, thanks for joining.
Thank you for having me, Ryan.
So if you don't mind starting by just telling everyone a little bit about yourself and kind of how you got to where you are today.
Yeah, so I went to law school at UCLA. I ended up working afterwards at a small boutique estate planning firm in San Diego. So my background was really in estate planning. You know, my father, he became a real estate agent, was looking for some help on the real estate side. And so I decided to get into real estate closings as well. And now more and more, my business is real estate closings and, you know, a little bit less on the estate planning side, maybe a 60-40 split. But yeah, that's kind of how we got into it.
For most people listening, they've probably heard the term estate planning attorney, but could you give some insight on exactly what that means you do?
Yeah, so as an estate planning attorney, really what we do is we plan for the eventual demise of someone, you know, and not just death, but also incapacity. So it's about who do you want to make financial decisions for you in the event of death or incapacity? Who do you want to make healthcare decisions for you in the event of death or incapacity? Where do you want your assets to go? How do you want them to get to the people you want them to get to, and what manner? It's all of those things. And of course, there's layers of tax planning involved as well. And sometimes there's planning for if someone needs long-term care or something like that. All of that's really part of it.
Do you feel that that provides a benefit in terms of how you can approach your real estate side of the business, just knowing that extra level of detail, you know, kind of down the line as far as things to plan for?
Yeah, I think to a certain extent. I mean, on the one side, when somebody is buying a property, it's something that oftentimes I'll at least mention to a client. Have you thought about putting the property into a trust or something along the lines of planning in that regards? But then also on the other side, you know, if we're buying a property and there's something in the chain of title, maybe somebody took it by virtue of a will, maybe there was a trust involved at some point. You know, having that background is definitely helpful, and knowing whether title is good or not. That would be the other way it kind of comes into play.
Yeah, I know estate planning is not always something top of mind, especially for first-time home buyers, because it's, you know, it's an exciting time. They're just looking forward to redoing the kitchen and moving in versus planning down the line. But I know it's definitely something that's super important. I'm sure a lot of your clients appreciate just having that reminder that they should be thinking about that. You know, you mentioned holding properties in trust. Would you mind just explaining briefly, number one, what is a trust in general? And then what does it mean to hold a property in trust?
Yeah, so I mean, a trust is basically a legal entity in which you have someone, the trustee, who holds the property for the benefit of somebody else, the beneficiary, whoever that may be. And so basically the idea is because it is this distinct legal entity, it's not technically owned by you. And so on a most basic level with, you know, the kind of basic living trust we do all the time, the real benefit of that is because it's not owned by you, it doesn't go through the probate process. But there are lots of other benefits. Now, to go back to your second part, what does it mean to be owned by the trust? Well, it literally means that, you know, title is held in the name of the trust. So on the actual deed, whether it be when you buy it or transfer it later, the grantee of the deed will actually be person X as trustee of the Y trust under agreement dated. And so it actually reflects the trust as the owner rather than just an individual. And like I said, there are many different benefits to that, including probate avoidance, potentially state tax minimization, all sorts of different things, and it depends on the type of trust, but that's kind of what it means generally.
I think in real estate, especially in the real estate investing world, that new investors often think of two options for protecting your asset as either putting it in a trust or holding it in LLC or corporation. A trust more oriented towards protecting the eventual sale or transfer of property once there is death in the family or something of that effect. Is that more the goal of a trust, or is it similar to an LLC where it can be protective now?
Generally speaking, trusts don't provide a whole lot of liability protection, either bottom up or top down. LLCs are great at providing bottom up liability protection. And when I say bottom up, what I mean is, you know, if there's an incident with the property or in the entity, right, that the liability can't flow up to your personal assets. If that's what you're looking for, you know, if you want to find a property to rent it out and you don't want to be exposed to liability in that regard, an LLC is a great option. It definitely is much better than a trust in that regard. And I know now, obviously know much better than me, but I know Fannie and Freddie are making it easier to transfer properties into LLCs. As far as liability coming down the other way, you know, if you're sued individually, this is a question that comes up all the time. Which one is going to provide liability protection? In Massachusetts, it's almost neither. If you're sued individually, they can definitely come after an LLC interest in any state. And in Massachusetts, we really hard, even with a trust, to protect your assets if you're sued individually. In some other states, there are so-called domestic asset protection trusts that can provide a layer of liability protection in the event that you're sued individually. They can't necessarily come after the assets in that trust, but in Massachusetts, we don't recognize them yet. So that's kind of difficult. So usually with trusts, our main focus is definitely on probate avoidance, getting assets to the next person in line that you want them to go to in the event of your death or even in the event of your incapacity. But it can also be on estate tax minimization. There's a lot we can do with trusts in that regard. And then for certain people, for trying to qualify for Medicaid, that type of thing. Again, trust can be a great option that LLCs don't really get. But in terms of you want to protect yourself in the event that someone slips and falls down your stairs, LLC all the way, no question.
Yeah, that's a great overview because I feel like that's often something that isn't necessarily understood clearly, the differences between the two, and understanding that a trust isn't necessarily a liability protection as much as it is long-term planning vehicle, and to avoid some of those probate repercussions and what have you. So in respect to that same conversation though with LLCs, I know LLCs protect you against personal liability, but it's only if you run them like a business. I know Massachusetts, and like you mentioned, some of these entities can be pierceable to get back to the owner. Would you mind speaking just a little bit to some of the things that someone might want to avoid when running an LLC to make sure that they are protected and their entity is in fact, as close to non-pierceable as possible?
An LLC, which is actually a newer idea, right? Corporations have been around for well over 100 years. LLCs have really only been a thing for about 40 years. One of the nice benefits to them over a corporation is that they are more flexible. You don't have to be quite as strict as you are with a corporation. You don't necessarily need to have annual meetings and minutes and all of that type of thing that you need with a corporation. Not to say that the regulations of a corporation are extreme, but it is a little bit more flexible and easy with an LLC. I think the biggest thing, maybe the cardinal sin, is to commingle assets. If you're taking money out of your LLC account to buy dinner or something for you and your friends, that's a big no-no. Or if you're paying the expenses of the LLC out of your personal funds, if you're just generally not respecting that it's a separate entity and that the expenses and the income should go to that entity, that's kind of probably the biggest thing. Ends up maybe a court allowing a creditor to reach your personal assets. The only other thing that seems to come up too often is if you really undercapitalize the LLC, so you're constantly just bleeding it dry. To a certain extent, people want to do that obviously, and that's kind of the intention, but to go too extreme, there have been a couple of cases. But I think the biggest thing by far is just, not respecting it even to the extent of commingling assets. That's the biggest thing not to do.
Yeah, I feel like LLCs get this assumption that you're impenetrable once you have one established and you're completely safe, which is not the case if you don't run it properly. And you're right, it should function as a business. That's the only way to, number one, make sure that it does function efficiently, but also you're covering yourself protection-wise.
Right, and especially if someone has a sole member LLC, I would say there's even more to be careful of, because now courts have they've gotten to be a little bit more strict about it, and there's sort of, maybe to a certain extent, a small presumption, if you will, that it's not necessarily a completely separate entity if you're running it as a sole member LLC. So that's something to be even more careful of than if you're, an LLC with multiple members. I think that if you're an LLC with multiple members, court's more inclined to say, yeah, that's its own thing. If you're a sole member LLC, they're going to be a little bit stricter with you.
I guess it makes sense. You have much more control and liberty over a single member LLC versus having something that essentially is more set up like a business because you have multiple members, multiple partners who are all part of the decision making. Yeah, that's definitely important to understand for anyone listening who's thinking about investing in real estate. And to your point earlier, Fannie and Freddie, they're making it easier for LLCs to become, established once you own a property with a conventional mortgage. But in that same conversation, people don't always understand when you can and can't transfer your property into LLC, especially when you hold a mortgage. Now, I'm sure you get this question all the time. What is the right way to approach transferring a property into an LLC? Because from the mortgage side, depends on your servicer, you should ask permission to transfer the property into an LLC and they'll grant you permission to do so. Otherwise, there's a due on sale clause in the mortgage. Would you mind speaking to that clause and what effect that could have?
Yeah, definitely. And there are really a few different things to think about before putting property into an LLC. more so than even just the due on sale clause in the mortgage. But we can start with that. I think to a certain extent, a lot of people have been advised, well, it's easy, just transfer the property into an LLC. And, anybody can go to an attorney, have a deed prepared and record it. You don't affirmatively need anyone to agree. You can just go ahead and do it. But it doesn't mean that you're not going to have problems later if you do that. So one of them is, as you said, almost every mortgage out there has a due on sale clause. And so basically the idea behind a due on sale clause is that if you transfer the property, to someone else, it's considered then a sale, and basically the entire note comes due if the lender chooses. And, some people have said, well, as long as you keep paying, no lender's really going to do that. And it's possible, but it is a big risk. And I especially think now it's a big risk with interest rates rising, because if you're locked in at, say, 3%, and now rates are 7%, to say the lender isn't going to want to get their money back so they can lend it to someone else.
Bring their interest back to market, sure.
Right, exactly. So I would be very hesitant to risk that kind of interest rate swing. So yeah, the proper way to do it would be, so if you're transferring it to an LLC, because there are certain exceptions where you can always transfer it even without permission of the lender, because there's a law from the 80s where Congress basically said to lenders, okay, we're going to allow, because before that it was technically unclear whether due on sale clauses were fully enforceable. So Congress passed a law, and they basically said, look, due on sale clauses are definitely enforceable. You can put them in all your mortgages, but we're going to have certain carve-outs. And so there's certain carve-outs for if you get divorced, transferring it to a spouse, if you die, transferring it to next of kin, if you're transferring it to a basic revocable trust. All of those things you don't need permission for your lender from. But LLCs are not an exception to that. So if you transfer it to an LLC, your lender could definitely trigger the due on sale clause and call in the note if they want. Right. So really the best thing to do would first be to figure out who your servicer is, because I know there is new guidance from Fannie or Freddie, I forget which. One of them now says that you can transfer it to an LLC as long as the LLC members are the exact same people on the original deed without it causing the due on sale clause to be triggered. So if you're in that category, then, you're basically fine. You can go ahead and proceed on that front. If you're not, then the best bet is to contact the servicer and ask them if they're willing to consent to it. A lot of times they will eventually consent to it. It's not necessarily the most easy thing, because a lot of services take like months to get back to.
Yeah, it's the huge entities, sure. You're dealing with customer service, landline, so.
Right. So that can be a little bit of a pain, but that's definitely the better way to do it. It's better just to take your time, deal with those servicers, rather than just to do it and risk that something's going to go wrong.
I think with the due on sale clause, the risk is just so much greater than headache you might have to go through for the process. Like, it might take you a month or two, but having to call a note due, that's a significant risk to have put into question if you decide you want to go about doing that without asking someone. So yeah, it's easy enough to contact your servicer, and like you said, it's becoming easier to transfer an LLC, and there are programs you don't have to ask. So just figuring out which way is the best way to approach it is definitely important.
And, going off of that, I said there are a couple other things. You should also always look at your title insurance policy, because you may be voiding that by transferring it to an LLC. Older policies, you can void title policies even by transferring it to trust. So you really want to always look at the title policy, make sure that it's not going to be an issue. Or, again, transferring it to an LLC 9 times out of 10, it is going to be an issue. And then you probably want to reach out to the underwriter or an agent for the underwriter and get an endorsement for the policy. And, they're not usually very expensive. They're usually like $150 to $200. And for that, they'll endorse your title insurance policy so that it's still valid. Because otherwise, you transfer it to an LLC, you think all is well, and then later on you find out there's a title issue. You try and make a claim on your title policy and you can't. Back when I was working in San Diego, I actually knew someone who had transferred their beautiful ranch in South Dakota to some entity. I don't even know what kind it was. And then one day they're on the ranch and this gas company comes and they start preparing to basically do like fracking. And the guy's like, well, wait a minute, I own the land, you can't do this. Turns out he didn't actually buy the subterranean rights. So the gas company actually did own those, and they were permitted to do what they were going to do. Wow. His title policy made no exception for it, so he could make a claim on the title policy. The problem is when he had transferred the property, it had voided the policy. And so now he was completely unprotected.
Wow.
That's why you always want to look at that as well.
Definitely a crazy outlier story with fracking. I mean, you don't need
Probably
typically
not
anticipate
here, but
but to that whole point is title insurance. That was one of the questions that I definitely wanted to cover today. And do you mind talking a little bit about what title insurance protects an owner against and kind of why it's advised you should get it?
Yeah, so I mean, title insurance basically protects an owner in the event that there's any title defect. And title defects can take many different forms, and I think a lot of people don't realize that there can be so many of them.
Fracking.
Yes. In New England, subterranean rights are not really an issue we deal with a whole lot, just like we don't deal with water rights as much. Both of those things are big problems out west, not as much here. But, things that do come up all the time are mortgages that were not properly discharged from a long time ago. We see it all the time with people selling properties, and then they find out that they had a mortgage that they took out in 1990 that never got discharged properly, and we can't sell the house because we're missing that discharge. And then sometimes they do get missed. I was helping someone sell a property the other day, and he had a mortgage that was taken out in 2005, but he bought it in 2015. But when he bought it, the person just didn't notice the mortgage, and it just went and continued on. So that's another, so that's one of the most common, if not the most common problems to come up. I mean, another common issue would be like tax deficiencies. If the taxes aren't fully paid up through the date you buy it, that can come up somewhat frequently. You could also, though, have other issues that are much less noticeable. For instance, it's being deeded by like a corporation or an LLC, and it's not signed off on properly. If you have it deeded from a corporation, you're supposed to have both the president and treasurer sign the deed as president and treasurer, and that doesn't happen sometimes. And a lot of times, title examiners will miss it, and it'll go to you, and then you have a problem because technically it's not done right. Or if it's from an estate and it's signed as personal representative, but they don't have a power of sale, so it really should have been through the beneficiaries directly or the devisees directly, and that's not done. They don't sign it in the proper capacity. I had a deal that was tanked because of something like that. All of these things can come up, and I think a lot of times people think, oh, the last owner owned it for 30 years. Well, who's to say there aren't 8 mortgages if they kept refinancing, and who's to say that every time the discharge was recorded? Or it's a new build, no title issues there. Well, the land still existed.
Exactly.
Right? I mean, basically any piece of land, if you go back far enough, you're going to find some grant from a king in New England, right?
How far do you go back when you look?
So in order to provide marketable title, we have to look at least 50 years or to the next deed for consideration, basically. So if you look back 50 years, that puts us in 1972. But if the deed conveying, before that is from 1914, well, you have to go back to 1914. Wow. So you basically have to go 50 years plus however long until you get to the next deed for consideration. Most things, everything has a statute of limitations, and that's why we don't necessarily have to go back indefinitely.
Right, to eons, yeah.
Most things are going to be out after 10, 15 years. Mortgages, if they don't have a date on them, will go back as far as 35 years. And an actual chain of title issue, which are somewhat rare but are the worst kinds, if you have, that's a 50-year statute of limitations. So okay. That's why we go back 50 years.
Yeah, well, I think just the plethora of examples you're able to give just shows how common these things are. I know personally with my family's experiences, we've had 2 instances where we've needed to use title insurance, 2 title claims that thankfully we were protected from. But if we hadn't bought the title insurance, then, we would have been out legal fees and had to have dealt with that whole issue. And that's just, 2 out of a small pool of properties versus you have plenty of examples. So it just shows that it does happen all the time. I think people often think that it's, like you said, oh, it's a newer property, there's nothing wrong with it, or it's been one owner for 20 years, but who's to say that those behind-the-scenes things haven't been executed like they should. So, and then, in regards to title search, title exam, what other things does the real estate attorney do throughout the process?
Massachusetts, obviously, or I think most people know that we're generally considered to be a 2-contract state. So usually the first time that we get involved is after the offer is signed, we begin working on the purchase and sale agreement. So usually the seller's attorney will draft that, But of course, they draft it for the benefit of the seller, so then the buyer's attorney will review it, take out anything that they feel like is overly harmful to the buyer, as well as usually add on a so-called buyer's rider of provisions basically for the benefit of the buyer. And then that gets sent back to the seller's attorney, and usually the attorneys go back and forth until there's something that both parties agree on, and then they go to their clients and review it with them. So that's kind of the first thing. Then, like we talked about, the full title review, on the sell side, that obviously you don't have to do the title review on the sell side, but if there are any title defects or issues, then the seller's attorney has to deal with them and correcting them. And then, of course, the settlement. So obviously the lender is going to prepare the preliminary CD. They're going to send it over to the closing attorney or the buyer's attorney usually to review it all, basically add in things that the lender might not know about. They'll go back to the lender, make sure that they match. Then they'll bring it to the seller's attorney, make sure that they're in agreement, and then they'll bring it to the buyer to make sure it looks good with them. And then on the day of the actual closing, the buyer's attorney is the one who meets with the buyer, goes over all the documents, hopefully explains them to the buyer, has them sign everything, and then they put in, the deed, mortgage, municipal lien, certificate, 6ity if applicable, in for recording. And then once it's on record, that's when the buyer's attorney basically disperse funds to all the relevant parties. So sure. All of those types of things. And on the sell side, you're also preparing the deed. You have to sign all the seller documents. If I'm on the sell side, I always order the final water and sewer bill. So all those little types of things that have to get done.
Sure. Yeah, you mentioned 2 contract state. I think that I'm very grateful for the fact that we are, just because I'm working on a deal now where one of my clients is selling a property in New York. And New York is primarily 1 contract state. So the real estate agent essentially makes the binding contract. Number one, agents aren't attorneys, right? They're looking out for their buyer's best interest, but they're not versed on legal language and making sure that they're protected beyond just the terms of the offer. And there's a scenario now where there was some work that was done on the house that came up, wasn't properly permitted, and part of the offer that they made didn't really stipulate whether or not this was to be addressed. So some of those challenges where having an attorney involved who understands the legal aspect of it and how to make sure you're protected can really help save a buyer from any extra liability or, I guess, challenges throughout the transaction. So
yeah, I personally go back and forth on whether the 1 contract or 2 contract makes more sense. If it's a standard form, sometimes in a way I'm like, well, maybe that would be easier for everyone involved. But where we are a 2 contract state, I do think it is important to have an attorney, because usually when you don't, the other side still will, and they're going to put in all of these things, and you're not really going to necessarily know if that's good or bad. And, a lot of times they'll force their agent to review it. And, don't get me wrong, agents are great. This business moves because of them. So many times I'm like, we attorneys just need to get out of it because we're just making a mess. And I'm like, all right, we got to get the agents involved, have them fix the problem. But when it comes to something like a contract review, they're not necessarily going to know, what should be in there, what should not be, because again, that's just not their job. And so I do definitely in that situation recommend that somebody have an attorney to really look it over, because you get into a bad problem.
Yeah, agents do definitely, drive things throughout the transaction and keep things moving. But yeah, contract-wise, that's not their job. So they don't know what things they should have in there or what things shouldn't be in there. And you always get the scenario where it's like, oh, my uncle's an attorney and he's like a litigation attorney, and he, puts in a ton of verbiage that no one really understands. And having someone on your side who can at least break through the noise is helpful. So in regards to, I guess, what you look out for in the process, you say that you should have an attorney to help protect you and just have another voice to look through these contracts and things. What are some of the most common problems that you run into in a real estate transaction where you step in as the attorney and it's your job to help solve them?
Different phases have different problems.
Title's definitely one. We talked about that.
Yeah, so we already kind of talked about the title. And in Massachusetts, you're always going to have some attorney look over the title, whether it be your attorney or the lender's attorney. Unless it's a cash deal and you literally go in with no one, which I don't know that happens very frequently. That would be interesting if it did, but there's probably almost always going to be someone looking it over, and honestly, that's where most of the issues are most likely to pop up on our front at least. But other things do come up. Certainly in the purchase and sale phase, sometimes the parties just get stubborn and can't agree on anything. Usually it's nothing that's that's fatal. But, it can be little things like, is there an appraisal contingency for the deal? Or even what it means. Like if an agent writes into an offer that they're waiving the appraisal contingency, does that mean that, it doesn't have to appraise as long as it appraises for enough that the loan can be issued? So even if, the person has to pay PMI, they're still going to go ahead and buy it? Or does it mean it flat out doesn't matter what it appraises for, you have to make up the difference in cash? So if it appraises if it's a $500,000 house and it appraises for $300,000, and you can only lend to a maximum of 95% LTV, that they're going to have to put down, was that $215,000? Is that really what they mean, or do they mean just they're intending to put down 20%, not pay PMI, but if it doesn't appraise and they have to put down, they have an LTV of 95, they'll accept it.
Sure.
So something like that people get stuck on all the time.
Yeah, that makes sense.
Whether the seller has to close any open permits or not, that can be a point of contention that comes up a lot. Again, nothing that should hopefully derail the deal, but
right.
Sometimes there can be loose terms and offers that people aren't entirely sure about. You see a lot of people having inspection for informational purposes only.
What does that really mean, right?
Exactly. What does that mean? Does it mean that regardless of what the inspection says, that if you back out, you lose your deposit? I think that's kind of the most widely accepted reason or understanding. But then, I've definitely heard a lot of people say, well, no, they can get their deposit back. It just means that they won't try and negotiate or get money off. So what does it mean?
Right. So, is it information that can be acted on? Right. What are you doing with the information?
So that's another thing that can come up sometimes. And, it can be little things like representations and warranties that one side wants to be, that the buyer side would want the seller to make and the seller doesn't want to make. And of course, hopefully you end up meeting in a happy medium. And that's also where I brought up my comment before, sometimes the attorneys just end up butting heads and nothing gets done. And I'm like, all right, this is ridiculous.
Just let the agents
And I just call the agent.
Smooth it over.
You got to just work this out. Come to a deal. Tell both attorneys what to do. And
we'll make sure it's written properly on paper.
Exactly. Yeah. And 9 times out of 10, they'll talk and they'll be way more reasonable about it, and they'll come up with a solution, and then that's what we'll put down.
Yeah, they're the handshakers. They'll get it done for the most part. So
exactly. So, those would be the types of problems that might come up there. Hopefully you don't have too many problems that come up at the very end towards closing. I mean, it could happen, but hopefully not.
Yeah, ideally, you sniff most of those out in the beginning. When real estate functions best, when it's just transparent and you don't have to dig for the right answers, because that's. In the end of the day, like you said, when you go through a title search, when you go through your proper due diligence, you're going to find out anything about the property that someone's trying to hide or really smooth over. So, when it's just transparent and upfront, and the deal's the same as it was from the first handshake to the last, it just goes the best. So.
Yeah, but of course there can be some little things, in this past year I had someone spring that they were going to be signing under power of attorney, the deed, at one day before closing. And I was like, well, the agreement doesn't say you can do that, and you never sent me the power of attorney, and you never asked me about this. The seller's been incapacitated for 6 months, so take it or leave it.
And you can't sign, can you sign a POA when someone's incapacitated? Do they have the ability to?
No, they had already signed it.
Oh, okay.
They had signed it before becoming incapacitated. But usually we don't like to actually have a deed under a power of attorney. All the other documents, sure, but the deed itself.
That's the keys.
Yeah, so, and just to spring it on you at the last minute is not necessarily ideal. Of course, we also had a deal where the seller's attorney told us, they were like, can we move the closing date up a week and a half? We were like, well, maybe. And they were like, close this Friday. It's Wednesday. Yeah. And we're like, I don't know, maybe, I guess. And we're like, why? And they're like, because we really think the sellers might die before then.
Wow.
And they own it individually. So in that case, we knew we were buying it under POA.
Sure.
But basically they were saying, if the person dies, the POA is extinguished. It's not in a trust. So if they die before you buy it, we're going to have to go through probate before you can get it.
Right.
And they're like, so do you want to move it up a week and a half so that we can make sure that, this happens? Wow. So that could be another example of something that could come up at the very last minute.
Wow. Yeah, that's the extreme. But we've heard similar stories, but not quite like that. And that whole point about, buying a property that might have to go through probate, you see often properties that are going through an estate sale. Would you mind talking through just, I guess, some of the challenges that presents, and then how you might want to consider buying a property like that, what things you should think about if that's something you're considering?
Yeah, I mean, so at the end of the day, it's not really a challenge per se. Usually it just means waiting. You could have to wait for the initial probate to go through. And then if there's no will, or if there's a will and the will doesn't specifically authorize the personal representative to sell the property, then someone's going to have to go back to court again and petition for a license to sell.
Okay.
Which again, it's not fatal, but it adds another 2-3 months to the process. So I don't know that it's anything that I would discourage someone from doing. And if you're on the buy side, it's really not a big deal. It's nothing you have to do.
I think you might have more negotiating power because you have to wait, right?
Right. So the main thing is just, know you have to wait. And if you're okay with waiting, then I say go for it. But of course, if you're borrowing money, you have to consider rate locks, that type of thing, which could just take more and more time. And if you're in land court, it's going to take even more time. So all those things just have to consider.
Yeah. And you mentioned probate. I know most people are familiar with the term, but could you just briefly summarize, what does the probate process look like?
The probate process is just the process by which the court determines, upon someone's death, basically who's going to take control of the assets and what they can do with them. So if you die with something in your name individually, well, the second you die, you can no longer own anything. So, if Ryan Richards owns a property, the second you die, it's no longer owned by Ryan Richards, it's owned by the estate of Ryan Richards. And the only way that someone can then sell it or do anything with it is that they have to probate your estate. So that means basically going to the probate court in the county you're in and filing a whole bunch of documents, if there is a will, including the will, and then basically getting the court sign off to then distribute out the assets and do what you want with them. And, if all the beneficiaries are accounted for, it shouldn't be that long of a process, a few months. If some of the beneficiaries are uncooperative or you can't find, then it's going to take a lot longer.
Or if there's improper documents, right? I'm sure some people probably don't have an estate plan. So what happens if you say I own a property, I don't really have a will formally set up, and I die? What happens to my property?
Yeah, so then somebody just has to probate it going through the laws of intestate succession. So that doesn't necessarily, make it that much harder. It's kind of a very similar process. You just don't have a will to file. And then basically instead you have to identify who the heirs at law are, and then you have to get all the heirs at law to sign off, and then you can probate it the same way.
Sure.
So, in your case, you're not married, you don't have kids. At least I don't think so.
No.
So,
not that I know of.
So your parents would be your heirs at law. So if something were to happen to you,
okay,
your parents could basically petition the court, and if both of them sign off, it again should be a fairly smooth process. It's just a matter of waiting.
I feel like a lot of people who would probably be listening to this are first-time home buyers, or in that, maybe move up, move down phase. At what point would you recommend someone considering getting their estate planning under wraps?
I mean, I think at any point it makes sense to have something. But, certainly if someone has minor children or something like that, that's always the point where I would say you should do it. And I know this doesn't really deal with real estate, but I mean, one of the biggest reasons why I would say at that point is also just so you can appoint guardians for your minor children. I think that's one of the biggest concerns that young parents have. Appointing permanent guardians, as well as if that person you want isn't even here, appointing a temporary guardian. What would happen if you died right now? Who's going to take care of your kids? Having someone who can get them so that they don't end up in foster care ever. That would be really probably for most parents of young children the most important part. But then also having something so that the assets can clearly make it to your children without having to put a huge burden on the family members who are going to have to deal with it, as well as kind of, having something in place so that they're held for the children by the people you want rather than the probate court holding them. Because again, if they're minor children, the court's going to get very much involved. So all of those things. Not to say that someone who doesn't have children shouldn't do it. I mean, obviously, like I said, everyone should do it, but certainly people with young kids even more so. And then, of course, as you get older, certainly.
Obviously, a great perspective to look at it from, but every parent plans for their kid's future. But when it comes to things like estate planning, I feel like the general idea is that you're really just worrying about yourself. So most parents aren't as open to worrying about themselves as they are their kids, but it really is their kids that the estate planning protects it for. It provides for the assets to flow properly to the children and for your wealth to transfer properly. I know a lot of, trusts and wills are set up such that kids get certain amounts of money at certain age at age limits so you can make sure that they handle it properly. And to your point, you have people who you trust to manage the money to be able to help provide those kids some opportunities with your wealth in the event that you do pass. So it is very much oriented towards protecting your kids, your assets for those who don't have kids. But
yeah, and I mean, if you think about it, you're going to be gone. So it's really not about you at all.
It's not about you at all.
It's really just setting it up so that your children are set. Especially if they're under 18, they're minors. They're going to be at the mercy of who's taking care of them. You want to make sure that there are things in place so that they're taken care of in the way that you want.
And I was reading on your website, about estate planning is not life insurance. And I thought that was an interesting comparison because I think a lot of people do consider life insurance, to be a planning mechanism, which, yes, it's a benefit to have. It's, I guess, a remedy in the event that you do die. It provides relieves the financial burden from your successors, but it doesn't necessarily plan for asset allocation and wealth transfer, and it doesn't cover things like managing probate court and those things. So I thought that was interesting to see comparison.
Life insurance can be an extremely important thing. My wife and I both just recently got policies. It has to be done in conjunction with estate planning. Because, imagine if, a lot of people have life insurance policies. They might have their spouse as the primary beneficiary and their kids as the contingent beneficiaries. Again, though, without any kind of planning, you're not going to be able to have any say in who basically controls it for the children until they turn of age and how it's controlled. And all of those things are going to be handled by the court instead. So I definitely think it's something, that can be important and part of your overall plan, but you do need actual planning.
It's a part of the plan, but it's not the plan. So, and estate planning is exactly, the way I think of it is it's like controlling your destiny. It's not your destiny, but your kids' future, and making sure that your wealth gets to be properly managed when you're gone, because when you're gone you have no say. So
exactly.
I do feel like with estate planning though, it's not something that's ever really top of mind for a lot of people. It's just something that falls to the back burner. At some point you realize I have to do this, but it's usually when you're old or when you're not like when time is really starting to dwindle that you're like, oh man, I got to do this. But
no, definitely. And that's why I say, especially with younger parents with young kids, it's something that a lot of them don't necessarily think about, but even just having something simple in place just so that, your kids are protected.
And then what's the difference between a living trust and a non-living trust?
A living trust just basically means it's a trust that was created while you're alive, as opposed to a testamentary trust that's created upon your death through a will. That's really the only difference. I think people use the term living trust to mean somewhat different things.
Sure.
But on a technical level, all a living trust is a trust that you create while you're alive. I think most people, when they say living trust, they usually mean like kind of a basic revocable trust for probate avoidance. But really a living trust, like I said, is anything created while you're alive. And I think it's definitely superior than testamentary trust because you get to avoid probate.
Right. But that's process, it's time, it's money. So that's if you can avoid that. And then essentially you're passing that time burden on to your successors too, right? Because it's their job to manage.
People who are older, who have children who are adults, it's a pain, but it's like, okay, well, they're the kids, they're getting the assets. But especially for people who have younger children, you're going to basically be putting this burden onto someone who's not even getting the benefits, right? You're asking a friend, a family member to kind of administer this for you, and they're going to have to go through all this extra trouble and work just as a favor to you.
Right, just because you didn't do it when you were alive. Right.
So, in that case, I would definitely say get your things in order, make it as easy on those people as possible.
I know it's definitely something that I'm young, but I've never really, it's not top of mind for me. It's always, okay, well, how do I protect my asset? Okay, I put it in an LLC, run it like a business. All right, that's great. And then you think about the next thing that you're doing to make money, but it's never protecting money. I feel like that's often missed across not just asset protection, asset planning, but just general life. People don't think about how to protect their money. They just think about how to make more or spend it. It's never, how can I protect it? So thank you for joining me for another episode of The Real Estate Lens. I hope you found today's content to be valuable. If you want more information on my guest, attorney Josh Cali, or have some questions for him, his website and email will be listed in the description below. If you want to set up a free consultation to discuss your estate planning, you can go to his website at www.mycalilaw.com. All of my contact information will be listed in the description below as well. I'd be more than happy to help answer any questions you might have regarding real estate or mortgage financing. For more information, check out my Finance with Team Richards Instagram page where I post market updates and give helpful tips for buyers of all types. Thank you for listening and hope to see you again.